I am pleased to introduce James Roberts as our next presenter/speaker today. James is a senior general attorney for BNSF Railway Company. He's based in Fort Worth, Texas. He's responsible for casualty litigation for 16 states on BNSF systems. During his decade at BNSF, he has also served as the general director of claims. Prior to joining BNSF, he practiced law for 12 years here in Montana, so he's home. Welcome back, James. And he served as the National Association of Railroad Trial Council's regional vice president and is a member of that council's executive committee and a member of the faculty of that council's trial college. This is going to be an interesting overview. I've got some very interesting stuff from BNSF, and so welcome, James, and thank you.
Good afternoon. Kudos to all of you for hanging on after this late in the day. I put the over-under at about 6 people. You guys, I would have lost that bet. So thank you for your attention. Hopefully I can bring you a story here that's worth telling. Before we get rolling, how many people in here are attorneys? Okay, so we've got a lot of lawyers. For those of you that are lawyers, this case study is a lot like going back to your first week of civil procedure. I'm going to try to jazz it up a little bit. For those of you who are not lawyers, this presentation may cement your decision not to go to law school. At any rate, let's get rolling. So, in essence, what we're going to do here is, first of all, I'd like to introduce a little bit about what BNSF is, who BNSF is, and how it relates to Montana. I think it's important. We all have perhaps romantic notions about the railroad's history. We might have other thoughts about the railroad and litigation and its place in the state's history. I'll try to reconcile some of those and give you some data on the railroad. I'm not going to use this as a pulpit to come up here and whine about our experience in Montana court system. We're big boys and girls, and you win some and you lose some, but I am going to share some stats with you about how often we win some and how often we lose some. And then we'll get into the law school part, and we'll talk about jurisdictional jurisprudence. And I think if we boil it down a little bit to some common sense notions and go back in our mind's eye to cases like Pennoyer versus Neff and those cases we learned as newbie law students, this case will resonate some. And then finally, I'll get to the BNSF versus Tyrrell case and how it really is a game changer, not just for my company, but for industry nationwide and how that came about. And then finally, I'll conclude. At that time, I'm sure Bridger will have one of his airline things up, letting me know that the runway is about ready to close down. And I'll identify some challenges that we see, what's going to happen in the wake of this United States Supreme Court decision. So first, BNSF. It's been around 160 years. It started with a 12-mile stretch of track in Aurora, Illinois. And one of the things I've learned sitting here today is that evidently Montana has a vulnerable person statute. So I think we qualify. You know, next time we get banged around by a judge, I'm thinking about calling Chris and seeing if she can do something about that. The point of that is that the Great Northern and the Northern Pacific, they have been a part of Montana's culture for a very, very long time. Likely, everyone in this room either knows someone or has a relative that at one point in their life worked on the railroad, and what you would likely find out is that person worked there a very long time. That's one of the basic tenets that we put forward in these in my world. When we're talking to juries. The notion that if this is so horrible and so backbreaking and so punishing, Why is it that you were here 30 years, your father was here 40 years, and your grandfather was here 40 years? That doesn't compute, ladies and gentlemen of the jury, that sort of thing. It is a good job. It is an economic driver for this state. We employ 2,100 people here with very, very good paying jobs. The part that I guess the BNSF struggles with when we compare it against the other 28 states in which we roll in, is our function here to be an economic driver? Absolutely it is. That function should not include having lottery-like lawsuits. So that's something that we fought for many decades here. And like I said at the outset, we'll take our lumps in a fair fight. That's okay. But when the deck is stacked against us, this is a story about how we could get redress for that situation. So, who is this guy standing up here and what is he babbling about? I'm in charge of half the railroad's casualty portfolio, right? Lawyers have all sorts of disciplines, and we've heard from all sorts of lawyers today in their lane and their specialties. For example, Brooke here is one of my co-workers, and she's an environmental litigator guru. You know, that's malpractice if I touch that. My lane is FELA claims, and then any instance where a third party alleges harm, whether that's flood, famine, fire, asbestos claims, trespassers on the right-of-way, grade crossing accidents, anything that can go wrong in these 16 states. That's my job, is to oversee the litigation, oversee the lawyers, understand the jurisdictional rules, those sort of things. The FELA is, you've probably all heard tangentially, oh, that's railroad law, that's special law. And it struck me earlier listening to Judge Swandel, who talked about products liability, and he said, well, that's just Montana. And during my time practicing here and then being in Fort Worth, too often I've heard, well, it's just railroad law, you're supposed to lose. That's not the case. And I'm here to tell you that the deck is not stacked against defendants under the FELA. It is its own unique little niche in the law, but it's really not that different than any other kind of lawsuit where someone alleges injury. But there are unique challenges in litigating it here in this state. First and foremost, let me give you a broad overview of what the FELA is. Okay? It's the Federal Employers Liability Act. So go way back in history, 1908. Railroad was a big industry in this country, continues to be, but at that time it was kind of the only game in town. It was, in 1908, very dangerous work. So Congress enacted a law that allowed workers to sue their employer for personal injuries. Okay? Everybody else in this room would think, okay, if you get hurt at work, what happens? Work comp. The railroad is a fault-based system that allows a worker to recover for injuries if its employer was negligent. So often, at least in my experience in Montana and other jurisdictions, I don't want to single out the great state of Montana, judges who maybe hadn't encountered this before were operating under a misnomer that, oh, it's essentially work comp. The worker's supposed to get paid. We're leaving out a pretty big step before we make that leap. And that leap, that step is, was BNSF negligent? Not negligent light or kind of wrong. There is no such thing. It's sort of like having chicken pox, right? You either have them or you don't. And being negligent is the same thing. We either breached some duty to our worker or we didn't. Now, if you get past that threshold, the fault part, just like in a slip and fall, just like in a car wreck, just like malpractice, then you get to causation of the injuries. That's where it's different. Under the FELA, if the cause of the back pain, the leg pain, the whatever pain, is a cause in whole or in part, then we've got to pay. We get that. Okay? We understand that. It's been around since 1908. that law has been changed over time in certain jurisdictions, and certain belief systems have arisen on the bench that compromise us before we can get to a jury. And that's our goal, is to get these cases in front of jurors, because we feel like Montana juries, sometimes we get beat, but oftentimes we win. Oftentimes, and more times than not, Montana jury, if we're given a fair shake, they'll evaluate it reasonably. So part of this whole story is we just want a fair fight. That's it. And whether it comes from getting to a jury or having proper appellate review, that's all we're asking for. No more, no less. So how is the FELA different once you drive in within the borders of Montana than the other 28 states in which we operate? A few ways. First of all, apportionment of medical conditions. Under Montana law, and it's really up in the air given a 2017 railroad case, we're struggling with whether or not judges will let us put on evidence that someone, for example, had a prior back injury. So let's say I've got a worker who says, I was throwing a switch on the railroad, I hurt my back, and now I'm disabled the rest of my days. Okay, fair enough. But aren't we entitled to look into your past medical history, find out that you rode bulls professionally for 12 years before you came on the railroad, you had 2 prior fusions? Isn't that the kind of thing we'd like to tell the jury, and isn't that the kind of thing the jury would want to evaluate? Arguably, that's been taken away from us in the last 12 months. Statute of limitations. Unlike other cases where the burden might be on the defendant to prove statute of limitations, that is, you knew of your injuries and that they were purportedly related to work 3 years before you filed your lawsuit. Under the FELA, it is an affirmative burden of proof of the plaintiff, says so right in the statute. Within 3 years, you must bring this case. 2017, and then again, or twice in 2015, 2017, Montana Supreme Court came down with opinions that essentially eviscerate the statute of limitations case, where we had clear evidence that the plaintiff knew, in both cases it was a he, knew his injuries were related to work, or was told that, within 3 years of it being filed. Both cases were reversed in favor of the plaintiff and sent back. One was a defense verdict rendered by the jury. The other was a summary judgment given by a district court judge. Both of those flipped. So we don't know where we stand on statute of limitations. Forum non-convenes is a $10 word for you're trying your case in the wrong venue. And this was even before my time. Late 80s, early 90s, the Montana Supreme Court made an edict that we will no longer entertain any motion from the railroad complaining of where the forum is. So for that long, if a case is venued down in Billings in the federal system or in the state system, and all the doctors and all the witnesses are up in Hill County or in some other venue, the Supreme Court has said we will not entertain those. That is unique to Montana. There's no preemption in this state that we've been able to appreciate. As I mentioned at the outset, the FELA is a federal law, right? It covers railroad workers in an industry that goes among all the states. It's supposed to be uniform. It's supposed to be applied equally across the states. So if you say, let's take a grade crossing accident, for example. Engineer and conductor, you were going too fast, and that's why my client got hit at this grade crossing. The railroad should be entitled to come in and say, look, the federal government sets a speed limit. It was 60. We were going 53. You can't then come in and say that's too fast. It's preempted. How does that arise in other cases? Montana has a statute, a negligent mismanagement statute, that singles out only the railroad industry, that allows railroad workers to bring a cause of action against its employers for things like returning the worker to work outside of his medical restrictions, any other sort of hanky-panky in the workplace, poor supervision, anything like that gets shoved into this amorphous theory of negligent mismanagement, where punitive damages are allowed. Our theory on that has been, look, the FELA, under this federal law, is the sole remedy for railroad workers. You can't make an end run around it and put in place a statute that gives another remedy for railroad workers. Similarly, we just heard from the prior panel up here, those two were describing Railway Labor Act, those sort of things. There's protections in place for a federal employer like us if you have a labor problem, if your boss is treating you poorly. They have avenues to go that are governed by federal statutes. Why then do they get this add-on sort of addition? The railroad, we're going to try a case this summer or fall. The Montana Supreme Court held about 13 years ago that the railroad is an insurance company, that it has obligations to workers that make claims to deal fairly with it, just like State Farm, Allstate, and that if it doesn't fairly resolve a case where liability is reasonably clear, it can be held liable. So, in the particular case that's pending now, worker has a case, we couldn't come to an agreement, try the case, jury hits us for more than he demanded, and certainly more than we offered. Now he files a second lawsuit under Unfair Trade Practices Act. That too brings punitive damages. Again, we've argued sole remedy is the FELA. Why is he getting yet another bite and he's already walking around as a millionaire? Where are the damages? We have asymmetrical discovery, and that's not unique necessarily to Montana. We have several jurisdictions where judges will let plaintiff's counsel dig high and low for anything the railroad has had for decades and decades and decades. We fight that a lot. It is important here because a lot of our cases do not get to juries on the merits. So, employee steps in a hole, hurts herself. Isn't that what we should be trying to the jury and saying, hey, maybe we didn't provide her a safe place to work because she stepped in a hole? And through 2 years of litigation, it turns into the railroad hid documents. The railroad didn't get a video from the parking lot when she came to work that day. So the court's going to issue sanctions, and you can't even dispute fault, go try the case on damages. Those things happen to us a lot. Stale claims. Montana is a unique state in that you've got 3 years to file your case, right? You file it on the day before the 3 years. Well, you don't have to serve that complaint for another 3 years. So historically, we get faced with cases that were 6 years old. Memories have faded, railroaders have retired, supervisors are gone. And then what's part two of that? You spoliated evidence, you got rid of things. That's not the case. We just had people retire and that cord or that whatever disappeared. All these things in conjunction are very unique and very difficult. But that's all right. We have good lawyers, right? We have really good lawyers that, in the words of the guy that hired me in Fort Worth at my interview, he said, oh, you tried cases in Montana? I said, yeah. And they go through all that corporate speak, like, what did he say? What are your challenges? Opportunities. And I said, is that corporate for what am I bad at? He laughed. And I said, well, I'm a bad loser. And he said, well, what are you good at? And I said, well, I guess my biggest strength is that I can take a punch. And he said, you're hired. I was like, great. I had no idea what I was in for. So anyway, against that backdrop, let's talk a little bit about out-of-state litigants. Okay, so we have this constellation of stuff. We have 2,100 employees here. 99.9% of those employees go home, do their job safe, or go to work, do their job safely, go home, repeat for 30 years, retire, have children, come and do it, repeat for 30 years. That's how it's supposed to work. And there are a few litigants that have genuine cases, and we resolve them, and they come back to work. And then there are very few that we have to be in this adversarial relationship with, and we go try them. That's a pretty small number in Montana, should be, until you open up the entire United States and say, if you're hurt in Arkansas, but you live in Missouri, come on up to Montana and file your case. Right? And it had been going on for years and years and years, and our adversaries, plaintiffs' lawyers, good lawyers in their own right, national lawyers, will get their ticket in Montana, set up shop here, and then go out with their runners and hire clients, sign them up from all over the system, and file their case here. One of the things that we would do in voir dire when we're picking a jury is, and until that got shut down, is we'd say, ladies and gentlemen, does anyone here wonder how Mr. Roberts got to file his case in Montana? And all the jurors would raise their hand and say, yeah, why is that? And then the judge would tell me I couldn't say anything about it. But why is it that this person has driven past 600 courthouses to get here? Why is that? And that's the underpinnings of the Tyrrell case. So, I can say it in layman's terms like that, right? Why should someone that was hurt in Arkansas that's a Missouri resident get to file? It doesn't seem right, but what's the legal basis for why that isn't right? The legal basis for why that isn't right is personal jurisdiction, and there's two types of personal jurisdiction, okay? There's general and specific. I think the best way, and you guys are all probably smarter than I am, but I have to boil it down to examples. So let's say I've got a niece, she's in Louisiana, she goes to McDonald's and gets a shake, and the shake's got cockroaches in it and it makes her sick. All right, let's make up the ludicrous for a reason. She says, Uncle, I got sick, McDonald's poisoned me with cockroaches in Louisiana. Well, we're going to get a pound of flesh out of McDonald's. So I tell you what, honey, we're going to file your lawsuit in Montana. But I didn't see a doctor in Montana, and I've never even been up there. You know, my dad said, we don't need to go see you crazy bastards in Montana. I'm like, trust me, we got a case. So we're going to file it in Montana. How is it that McDonald's could be hailed into court in Montana for my niece's illness down in Louisiana? The plaintiffs would say, well, McDonald's operates everywhere. McDonald's is a member of the Montana state community. It has systematic and continuous contacts with the state of Montana and is therefore subject to general jurisdiction. And that's been borne out by the United States Supreme Court for years and years, dating all the way back to International Shoe. But in terms of what is general jurisdiction, it means it's not the specific event, it's the fact that you're doing business there means you've availed yourself of the state's laws. Is everybody tracking with me? Okay. Specific personal jurisdiction is just what I'm talking about in terms of McDonald's down in Louisiana. The specific act, it's arising out of or related to the defendant's contacts, okay? McDonald's served a shake in Louisiana, that's where she got hurt, they would have specific personal jurisdiction. All right, so how does that apply in our world? Historically in Montana, when we would make a motion to dismiss for lack of personal jurisdiction, the courts would apply, and I think rightfully so over time, it wasn't really an open question for a long time, the International Shoe Standard, which was systematic and continuous contacts. There's no question that we operate rail lines in Montana. There's no question that we have employees here. We have a presence. We have a systematic and continuous presence. That was the standard. We lived with it. They had general personal jurisdiction over us. What changed was this 2011 case called the Goodyear case. And in that, the fact patterns in these two seminal cases are just remarkable. We've got a bunch of teenagers over in France, and they're killed in an accident. The parents bring a wrongful death suit in North Carolina alleging that the tires were defective. The people that they sued, the defendants in that case, were Goodyear affiliates, foreign Goodyear affiliates. Now, these affiliates, sure, they made and distributed tires, but they didn't send them to the States. They made and distributed these tires largely in the Europe and Asian markets. So, the defendant, Goodyear's, these affiliates, said, North Carolina, you don't have jurisdiction over us because we don't have a continuous presence in your state. This is a one-off deal. You might have specific personal jurisdiction, but this analysis was general jurisdiction. So the court said, you know what? We do have contact over you because some of your tires, by hook or by crook, end up here. And even though those type of tires had nothing to do with that accident, you have a systematic and continuous presence in North Carolina. Up it goes. The United States Supreme Court takes cert. And this is 2011. So the court takes on this notion of general personal jurisdiction. And while they acknowledge that systematic and continuous contacts with the state may be viable, they stretched it a little bit and said it's not just the fact that you're there doing business, but are you at home in that state? Are you at home, Goodyear, in the state of North Carolina? And in the unanimous opinion, the court held that no, only states where those foreign entities were at home could general personal jurisdiction be held. And appropriately, they gave us an analogy between an individual and a corporation, right? For an individual, it's where you live, it's where you vote, it's where you get your mail, it's where you take your kids to school. That's your home. For a corporation, and let's take BNSF, by the international shoe standard, we'd be at home in 28 states because we've put ties and rail on the ground, and that simply can't be. So, we know that this Goodyear decision comes down, and probably like Leland and other people who've been up here today, the wheels start turning, and we think we may have a crack here to stop some of this forum shopping. Stop Arkansas people and Oklahoma people coming to Montana. Our belief was that once this case came down, any case filed like that in Montana under the FELA, we asked our lawyers start filing motions to dismiss, raise this issue. Okay? We didn't get any traction there, pardon the pun, with Goodyear, but we didn't get any traction. For whatever reason, and it will take a brighter mind than mine, the United States Supreme Court took up the issue again in a case called Daimler. And this was a game changer. And again, the fact patterns are so bizarre in these two seminal cases. 22 Argentinian residents, they file a lawsuit in California. And their allegation was, you Daimler, who are the parent company for Mercedes-Benz Argentina, are liable because your security forces kidnapped and killed our family members. So the question then was, does the court have general personal jurisdiction? Trial court said, yeah, we have jurisdiction over you because Mercedes-Benz USA sells cars in California. Supreme Court got a hold of it. And again, they they said, this is Roberts talk, this isn't the United States Supreme Court, but they said we weren't kidding in Goodyear, and we're going to tell you how. This old notion of substantial, continuous, systematic course of business isn't enough. We said what we mean, and we mean what we said, and that is for a defendant, for a court to have general jurisdiction and not violate due process for a corporate defendant, that defendant has to be at home there. What does that mean, to be at home? Yeah, they essentially have to be at home. And they gave us this definition. The court instructed, it's where it's incorporated or its principal place of business. For us, that was a bellwether moment. For Leland's constituents, that was a bellwether moment. BNSF, incorporated in Delaware, principal place of business, Fort Worth, Texas. These cases should be gone. So, same thing. We send out to our lawyers and say, if you have a case like this, file a motion to dismiss. Let's get it teed up. Let's have the Montana Supreme Court take a look at it. Surely, this one's pretty clear. So we did. 2 cases filed 3 years after Goodyear came down. 2 of them, and they were both in Yellowstone County. The first was a exposure case. A gentleman died. He alleged it was from his work with BNSF. Never set foot in the state of Montana. He worked in South Dakota, Minnesota, and Iowa. But his lawsuit should be in Yellowstone County. Nelson, another case, same time. North Dakota resident, he's over in Washington working on the tracks, hurts his knee, files his case in Montana. We get 2 separate decisions. Judge Baugh says, you know what, I think that Goodyear and Daimler's got something to it. And he granted our motion to dismiss. Judge Moses said, I don't know, I think you're continuous and systematic still. I'm going to deny your motion. We consolidate them both, take them up to the Montana Supreme Court. What's the Montana Supreme Court going to do? The court's analysis was they took the plain language of the FELA statute that talks about 2 things. It talks about venue. Okay? Venue is different than jurisdiction. It's where you can file it. Which federal district do you file it in? And second of all, the statute says the jurisdiction of the courts of the federal courts and the state courts are concurrent, which means judges like Judge Baugh and Judge Moses and Judge Gustafson, Judge Swandell, they can all hear FELA cases just like Judge Malloy, Judge Osby. You can file it in either place. As you might imagine, in our experience, these cases are not filed in front of Judge Malloy or Judge Osby. They are filed in the state court. So, Montana Supreme Court looks at this and it says, well, the statute says you're doing business, and therefore we have personal jurisdiction over you. That was error. But the underpinning of their decision was like so many others that we encounter both at the district court level and at the state Supreme Court, is this nebulous concept that there's a liberal construction of the FELA. The liberal construction of the FELA is that let's not get hung up on causation. If you've done them wrong and they're hurting from it, you pay it. I mean, that's the FELA boiled down. Liberal construction has been used to expand the FELA, as I mentioned earlier. So how did the Montana Supreme Court try to get around Daimler? 3 ways. First of all, they focused on railroad versus Argentinian automakers and railroads in opposition to Goodyear, those sort of things. The nature of the business ought not to have anything to do with whether or not you're entitled to due process. Nevertheless, they said the FELA. The transnational fact patterns, the state Supreme Court tried to say, well, this is dealing with foreign companies and that doesn't apply here. And then finally, they pointed out the injustice that a plaintiff would face having to travel to other places. Never mind the injustice that the defendant faces in a due process analysis in defending cases from Arkansas, California, wherever. And as I mentioned earlier, these were the ways that they misinterpreted the FELA statute. So we thought, all right, we can take a punch. Let's give a writ of certiorari a shot. You've got a 2% chance to get the United States Supreme Court. We took a shot. We asked for assistance from others. And I'm going to blow through this just an inch at a time. How do you go about doing it? How do you go to the Supreme Court, right? It's kind of like that episode from The Office. Did you guys ever watch The Office? When Michael declared bankruptcy, and he walked out of his office and says, "I declare bankruptcy." How do you do this? How do you go to the United States Supreme Court? You file a petition. Well, first of all, you hire boutique lawyers that this is their bread and butter. And they are really, really talented, really, really bright. Constitutional issues, they know them inside and out. They're not your car wreck lawyer. They all clerked for the Supreme Court justices. They issue spot. They put together arguments that are just fantastic. And I really was humbled to the extent, we would work with them. It was remarkable. They put together a petition. I think you guys, NAM, joined in, asked to be friends of the court, amicus briefs, early on, as did the U.S. Chamber early on. Lo and behold, January 13th, United States Supreme Court says, darned if we haven't addressed this twice recently, but we're going to take a look a third time. So what happens then? Boom. Then we bring on more talented lawyers. The United States government gets involved. They get behind the argument. All of these briefs are submitted. The Solicitor General of the United States asks for leave to argue when oral argument is granted. Oral argument, April 25th, 2017. You only get 15 minutes there, Leland, Lauren? Is that right, 15? And you talk about, I'm sure you wish I would condense my speech, but watching these artists condense their speech is something to behold. And the practice leading up to that, the moot courts after moot courts after moot courts with the best and the brightest in the country firing questions at these people. So when you get there on game day and the 9 justices roll out, it's pretty remarkable. And the audio of any Supreme Court case is worth listening to. In this particular case, this is the one thing that I felt the most vindication about was this exchange from Chief Justice Roberts and the respondent's lawyer. There was this discussion about, well, we just flat told the court, this is a magnet jurisdiction. These are all the ways and the reasons why people want to come to Montana. And it's not fly fishing and it's not hunting elk. So Chief Justice Roberts asked this lawyer, he says, what's the good, she made this statement of saying, and there's good reasons that litigants want to go to Montana. And he says, okay, by the way, I've read something about that. What are the good reasons? Answer? Well, from a litigant's perspective, if you want predictability, you want to know that the court you're going to knows the specialized area of law like the back of their hand. That's Montana. These judges know FELA cases because they see a lot of them. I think that's a good reason. And Justice Roberts says, that seems a little circular. You file all these lawsuits there, and because the judges are so good because you file so much, that really set the tenor for us. I mean, we thought, we got a stone cold winner here. And as it came out, the holding was, the language of the statute does not confer personal jurisdiction. The statute was talking about venue and subject matter jurisdiction. It reaffirmed its holding in Daimler, and ultimately held that Montana courts, by doing this, you are violating the due process rights of corporate defendants like BNSF that are not at home in the state. Big day for us. So, okay, big day for us, life goes on. What happens next? Here's what happens next. Currently pending in the Montana Supreme Court are 3 consolidated cases, because while all this was going on, there were 34 other lawsuits just like this. 3 of them have appealed from, after the United States Supreme Court came down and said, game over, they've appealed. They're going back to the Montana Supreme Court. The argument is this. Number one, because we register to do business in the state of Montana, as we're required to do, that means we consent to personal jurisdiction. Now, there's federal case law on that says no, that administrative requirement to register to do business is not a ticket. You're not giving up your constitutional right to due process. So we'll have to fight that out. We'll see how it goes with the Montana Supreme Court. Their other out is, well, we want to do discovery on jurisdiction. I don't know if that gets them anywhere, because it's pretty easy to say, here's our articles of incorporation, see the Delaware flag, and I'll take a picture of my office in Fort Worth if they want. And then finally, because one of these cases for sure, De Leon has been going on for so long, their argument is, you've consented to jurisdiction in Montana, but we raised it at the outset. The other aspect going forward is that, so what happened to the 34 cases? Our position is, when Goodyear came down in 2011, any case that was filed after that in this state, knowing what the United States Supreme Court said and gambling that the Montana Supreme Court wouldn't uphold it, that was your gamble. You're dismissed, you're out of Montana. So when they go file it in Oklahoma and they file it in Missouri and everywhere else, we file a motion for summary judgment on the statute of limitations, arguing your decision to flout the United States Supreme Court should not be something that tolls the 3-year statute of limitations. We're getting mixed results there, and more to come on that. How'd I do? 5 minutes? Okay. Any questions on that?
So what's your bet?
I don't. It's a public forum. I don't bet.
Good call.
Play it close to the vest.
Others? We've seen this consent to jurisdiction issue come up in New York, where the Office of Court Administration actually, which tries to play no favorites between plaintiffs and defendants, is advocating for a consent to jurisdiction rule, in that if you register to do business in the state, you are thereby consenting to be sued in that state. And it's troublesome for us because the Office of Court Administration, again, is supposed to be down the middle. But the problem is they just want volume, right? They like the volume of cases. Do you see that in other states, these legislative efforts to expand consent to jurisdiction and overturn Daimler?
Well, it's all come to a head with this, and we only have 2-3 jurisdictions where this really impacts us. Madison County, Illinois, state of Missouri, typically the city of St. Louis, and the state of Montana. Those are our trouble spots. And these wars are going on in real time right now. So I don't know the answer, and you're right, the constituents are going to line up on either side. They're going to say, corporation, you can't have it both ways. You cannot come in, avail yourself of our resources, but then say you're somehow not subject to the laws of this state. We would argue we're subject to the laws of the federal government. We've been telling you that for about 110 years now. A preemption argument. Anything else? Thank you very much to the Chamber for including me. I learned a lot listening to the other people, and took away a lot from this. So I appreciate it. And it's nice to be home. So,
Roberts. All right.